Get ready. 3 seconds. 2 seconds. Start. This appeal has been preferred by the appellants against the judgment and order dated 3/2/2014 rendered by the learned additional session judge in sessions case number 322/2011 under section 366/376/34 IPC, convicting the accused appellants and sentencing them to undergo rigorous imprisonment for 4 years and to pay a fine of rupees 5,000 each under section 366/34 IPC, in default simple imprisonment for 7 years and to pay a fine of rupees 5,000 each under section 376/34 IPC, in default SI for another 4 months. Stop. Para. The prosecution case, inter alia, is that on 26/5/2009 at about 5 p.m. the complainant lodged an izahar to the in-charge, police outpost alleging that on 21/5/2009 at about 9 a.m. while his daughter was going to the tailoring work at Delhi Market, the accused appellant number 2 at the instigation of accused appellant numbers 1 and 3 kidnapped his daughter. Full stop. At that time, his daughter had gold ornaments on her neck, ear and hands worth rupees 25,000 and a mobile phone worth rupees 4,000 with her. Full stop. On due search, he came to learn that the accused appellant number 2 kept confined his daughter in the house of accused appellant number 1 with the help of accused appellant numbers 1 and 3. Full stop. The delay in filing the izahar was caused for the said searching process. Full stop. Para. After receipt of the charge sheet, the learned CGM was pleased to take cognizance, and after furnishing the copies of relevant documents under section 207 CRPC, committed the case to the Court of Sessions, as the case was exclusively triable by the Session Court. Full stop. Accordingly, a case vide session case number 325/2010 was registered, and after hearing the counsel of both the sides, frame charges under section 366/376/34 IPC against all the accused appellants, and the same was explained to them, to which they pleaded not guilty and claimed to be tried. The learned additional PP has submitted that the evidence of prosecutrix can be relied on in view of the fact that she was minor at that point of time and she was forcefully taken away by 3 persons, and she was kept in confinement at different places for which she was unable to flee away. Full stop. She has given categorical statement in course of trial as against the accused appellants about forceful abduction, implicating the accused appellants with the offense alleged. Full stop. The learned trial court has rightly convicted the accused appellants. Full stop. Para. That apart, comma, if at all the victim girl was raped by three accused persons for 5 days continuously, then there must be some sort of mark of injury and other sign of sexual intercourse on the person of the victim, but the evidence of MO reveals that there is no sign of recent sexual intercourse, comma, no evidence of violence on her person, and she is aged about 20 years, comma, White Exhibit 5. That being so, comma, a girl aged above 20 years, if not a consenting party, then there must be some injury on her private part as well as sign of intercourse, comma, which is not found in the present case. Full stop. Para. In a given case, there being no eyewitness to the occurrence and the whole case centered around the testimony of the victim girl, who has given a inconsistent testimony during the course of investigation and the trial, and more particularly she being a major one, cannot be expected to give such twisting evidence unless motivated by falsehood. Her evidence being doubtful cannot be made the sole basis for conviction of the accused appellants. Full stop. The learned trial court failed to appreciate all above aspects in proper perspective of law and facts and has accepted the version of the victim as gospel of truth, whereas the prosecution failed to prove the charges against the accused appellants beyond all reasonable doubts. Stop.